early on. The pardon attorney requires a review and approval by the United States Attorney for the respective district. So contact our office or contact me. We can meet and visit about it, make a determination of whether that pardon application will receive the approval of our office and move forward. If so, that expedites it in the entire pardon approval process. My suggestion is that this is probably fertile ground for pardons, probably as fertile as it's been in the last number of years. So as you represent clients, again, if you think this is an appropriate option, let us know. Smart on Crime is one of those fancy-dancy Department of Justice initiatives, basically, which provides that it appears that the U.S. Attorney's offices across this country are getting very good at putting people in federal prison. This is the number of inmates in federal prison, and as you can see, it's steadily increasing to the extent that it's basically eating up the entire Department of Justice budget, and there's very little money left over for some of the other Department of Justice priorities. So the guidance is that, at least with respect to drug cases, we look at a number of factors before we charge offenses involving mandatory minimums with respect to drug offenses. So these are the Holder factors. These are the factors that basically we look at, and basically the guidance is that prosecutors should decline to charge a mandatory minimum when a defendant meets all of these criteria. John Hack, who's with our office, who handles a number of drug cases from the Sioux Falls office, is familiar with this. As part of the review process, this is something that we look at on a regular basis. The other sentencing enhancement provision with respect to drug offenses, in addition to mandatory minimums, is being able to file a 21 U.S.C. 851, basically superseding, or not superseding, but information alleging prior convictions. And so that enhances the likelihood that your client is going to get a significant and substantial sentence if convicted. And again, there's a set of criteria that we look at in making a determination whether we should file that information and pursue the enhanced penalties for drug offenses. Violence Against Women, the Reauthorization Act of 2013. You're going to hear from Troy Morley and Sarah Collins about this. Again, it's an important piece of legislation, especially in South Dakota, because right now Sisseton-Wahpeton Reservation is exercising the expanded jurisdiction under the provisions of the Violence Against Women Act, which means that the Sisseton-Wahpeton Sioux Tribe can exercise criminal jurisdiction over non-Indians who commit acts of domestic violence on the Sisseton-Wahpeton Reservation. Now, there are certain due process guarantees that they have to put in place. With respect to that, they have to have law-trained judges, prosecutors, public defenders. Their tribal code has to be published, has to be available online, has to set forth the specific provisions setting forth what kind of conduct constitutes a violation. But again, I expect more tribes across the country and in South Dakota to exercise the expanded jurisdiction. This is President Obama signing this. The next presentation will be Marlis Big Eagle with respect to victims' rights, but the one after that is Troy and Sarah talking about the specifics of the Violence Against Women Act. Another significant piece of legislation was the Tribal Law and Order Act. I talked a little bit about the statistics and the infrastructure that's being built at the tribal court level with respect to tribes exercising expanded jurisdiction. The Tribal Law and Order Act basically allows tribes, again with certain due process guarantees, to exercise expanded jurisdiction, in effect felony jurisdiction, and can sentence individuals up to 9 years. They can enter into agreements with the Bureau of Prisons to hold their inmates. So I think as we go forward, you will continue to see tribal prosecutors, tribal court systems, tribal governments exercising expanded jurisdiction over both Indians and non-Indians with respect to the criminal justice system. and violations of their laws. I put up the chart that shows about how many individuals are in Bureau of Prisons custody, and it's literally hundreds of thousands of those, obviously. So that begs the question about what happens when individuals get out of prison. And so we're also focusing on re-entry efforts in terms of individuals, once they're released from federal prison, and their re-entry back into the respective communities for which they came. This gives you a sense of why re-entry planning is so important. Incarceration rates are 743 per 100,000 in the general population. There's a higher incarceration rate among Native Americans, 921 per 100,000. And in kind of a sad state of affairs, Russia is second with only 577 per 100,000. So I don't know what that says about us, but you know, it's a fact. So re-entry populations, basically 650,000 people are being released from prisons every year, and another 7 million released from local jails. These are some costs associated with recidivism rates and costs of corrections. Within 3 years of release, 67% of ex-prisoners are re-arrested, and of that, 52% are re-incarcerated. The cost of corrections, whether it's at the state level, the federal level, or municipal level, is increasing exponentially. As you can see, it's basically at $75 billion, and it's higher than that now since 2008. The challenges facing U.S. reentry populations in South Dakota and across this country, but I think especially in South Dakota, where a lot of the federal prisoners, because of federal jurisdiction in Indian country, are rotating back and re-entering communities that are located in Indian country. So the challenges basically in terms of high unemployment in Indian country, housing issues, poor health, education, substance abuse. So we're working with the Standing Rock Sioux Tribe and the Sisseton Wahpeton Sioux Tribe right now to devise programs for re-entry in conjunction with those two reservations, kind of on a pilot program to see how it works. Troy Morley is our tribal liaison. He does government-to-government consultation with tribes. He's working with Sisseton and with Standing Rock on these programs. We've sent teams to training in South Carolina. They're back now working with the tribal governments in those reservations to develop programs. So re-entry does matter. It's a public safety issue for us. It basically contributes to stronger families, improved community well-being, and of course a smarter use of taxpayer dollars. Another big initiative for the Department of Justice is going to be voting rights and voting laws on reservations in Indian country. Basically, the Department of Justice is promoting legislation at the federal level, which basically will require that states provide the same equipment for tribal populations for voting, that they pay equal compensation to poll workers in Indian country, and that the state expands early voting into Indian country in the same way that it's been done in non-Indian country areas. A tribe also has the option under the legislation to request more than one voting site. The Department of Justice currently works in a number of areas with the state of South Dakota, with our office, to encourage early voting in Indian country. We've entered into an agreement with Shannon County, and we're looking at other areas, of course. We've provided poll watchers across South Dakota for voting to ensure the integrity of the election process. So again, that'll be an issue as we go forward. One of the hot topics over the course of the last couple of months, and I've had a number of press inquiries from U.S. News and World Report, and of course South Dakota media outlets, and I would expect that my phone hasn't rung as many times as Seth Perriman's done, the tribal attorney, who drafted the Flandreau ordinance and is here. So if you want to talk to him, you can. Basically, the one takeaway that I think you should take away from marijuana in Indian country is that the possession, distribution, manufacture, and cultivation of marijuana remains illegal under federal law. That has not changed at all. What has changed is the Cole Memo of August 2013 and a policy statement in October of 2014, which basically was guidance to U.S. Attorney's Office. And basically this was guidance to federal prosecutors to exercise prosecutorial discretion when it comes to prosecuting marijuana cases in either the state, where generally speaking the state has jurisdiction, and in Indian country. Where should federal law enforcement prioritize marijuana investigation and prosecutions given the limited resources? And the decision was at a very, very, very low level. So basically the guidance is that except under certain circumstances, generally speaking, we will not be prosecuting marijuana cases, although the 8 federal priorities that we're going to look at with respect to prosecution in marijuana are these. If there's the sale of marijuana to kids under the age of 18, for example, the Flandreau ordinance statute provides that there shall not be sale of any marijuana to children under 18. They've satisfied, if you will, that particular concern. Gang and cartel involvement, I'm not sure a huge issue at this point, although the evidence kind of remains to be seen. A big issue is diversion of marijuana to other states or to areas outside of Indian country. So it has to be tightly regulated and controlled so that marijuana cannot be bought in Indian country, for example, on the Flandreau Reservation, and transported to Sioux Falls for consumption. So that remains a big issue when we look at the regulatory provisions and when we look at issues with respect to prosecution. State authorized activity as a cover to pretext for other illegal activity. You know, violent crime getting involved is one of the concerns there. Violence and use of firearms. Public health issues remains a big issue. Again, we encourage ordinances or tribes to look at issues with respect to drug driving, hash oil explosions, public safety, edibles, and then where you're actually growing it. So what the Cole Memo is not is, again, it does not legalize marijuana. Basically, under the Controlled Substances Act, a federal statute, marijuana and hemp remain illegal. So it's not a guarantee of a safe harbor or immunity. It does not create a defense or a legal argument. This is the policy statement. If you're interested in getting that, I'd say let me know and I can send you copies of this. This is the policy statement that basically applies the Cole Memorandum to Indian country. It's a guidance memorandum to federal prosecutors regarding application of the Cole Memo in Indian country. And basically provides that if tribes are interested in pursuing marijuana, to work with and begin consultations with U.S. Attorney's Office. It's not a legalization memorandum, as I said. It remains illegal under the Controlled Substances Act. It's not a statement that tribes can legalize and commercialize marijuana, not a guarantee of a safe harbor, and doesn't create any defense. So again, it's not an all-encompassing legalization. Lastly, civil rights remains in the forefront of what the Department of Justice does, whether it's excessive force cases or hate crimes. We're involved in those kinds of cases on a regular basis across South Dakota and across Indian country. We're also becoming more involved and more active, basically, in terms of enforcement of the ADA, the Americans with Disabilities Act. We've recently entered into settlement agreements with the Rushmore Plaza Civic Center about ADA accessibility here in Rapid City. So there's a formal agreement between the Department of Justice and the Rushmore Plaza Civic Center and the City of Rapid City. Same kind of agreement with respect to Pennington County in terms of the facilities that they operate, that it has to be ADA accessible. An issue came up regarding summer camps in the ADA. We sent a letter to every organization that operates a summer camp in the state of South Dakota, indicating that they had to ensure that kids with disabilities basically have the same opportunities to attend summer camp as other individuals. And then an ongoing investigation by the Department of Justice right now, again under the provisions of the ADA, is that health care services to persons with disabilities, people have the right to receive those health care services in their homes and in their own communities, not to be shipped out elsewhere under certain terms and conditions. And as part of the prioritization of the enforcement of the ADA, it's the 25th anniversary of the ADA, so it's time that enforcement becomes a priority. The Department of Justice and the U.S. Attorney's Office will be sponsoring a disability rights conference, probably either in September or October, and you'll be hearing more about that as we go forward. So that's the issues with respect to the Department of Justice, U.S. Attorney's Office. Any last minute questions? I'll be around for the next couple of days if you want to visit about any aspect of anything that we've talked about in the U.S. Attorney's Office. So thank you.
It's going to take me just a minute to get the next presentation loaded up on the screen, so if you need to stretch, grab a water, something like that, go ahead, take a few minutes.